Hey guys, this is John Watts, and here's another comment. It's a little bit longer one, but I think it's got some good stuff in here. It's from J.A. It says, collection company is taking me to court. I quickly submitted the answer, so that's a good thing. The collection company sent me a copy of a credit card account statement, a letter from the original creditor saying the account was sold, and a statement from the collection company. It says cover letter. My question, all these documents have different balances, even though they're all sent to me together. Can I argue the validity based on different balances? Also, a letter from the original creditor is a generic statement saying account above has been sold. Can argument be made there? Anyone could have typed that up. Am I on the right track? Yeah, that's the end of the question. So, yeah, those are great questions. So, let me put some names here. I'm just making these up. So, let's say it's Synchrony Bank, and let's say it's Portfolio Recovery. So, you've been sued. And sometimes Portfolio Recovery and sort of their package of materials will have a letter from Synchrony Bank that says, and sometimes they call this a goodbye letter. It says, please be advised that the above account was sold to Portfolio Recovery. Well, that's not proof. That's a letter. It's hearsay. It's not a sworn statement. It's not offered in court. So that doesn't prove anything. It's a letter that says, hey, we sold it to Portfolio. And as Jay points out, anyone could have typed that up. And just because something's in writing doesn't make it true. I used to sometimes go to court and I would have something typed up that says, John Watts is the President of the United States of America. And I would sign it. I'd say, see, it's in writing. I must be the President of the United States. It's in writing. It has to be true. And I only did this with judges that I had a good rapport with. And people kind of chuckle over that, like, okay, I see the point. Just because something's in writing doesn't make it true. Lies can be in writing, actually. So that's certainly true here with this letter from the original creditor. And that doesn't prove that the debt buyer, Portfolio, in my example, still owns the debt. It just says, hey, at some point we sold it to them. Maybe they did, maybe they didn't. But the different balances, that can certainly be a thing, depending on how sort of small the difference is or how big the difference is. And you have to look at the dates and see what's going on. I mean, normally, here's how it should normally work. You have this credit card and its interest is being charged, and then they charge it off. And normally that will stop, it sort of freeze the amount. And so if it's sold 6 months later, it shouldn't be any different. And then after that, it shouldn't be any different. Now, there are exceptions to that where it's okay to charge interest, but it would certainly get my attention. Now, again, are we talking a dollar difference? Or are we talking about, $5,000 from the original creditor, and now Portfolio says it's $6,000? That's a bigger difference. And so I'd want to know on that. And that would certainly be an argument that I would make to question the validity of this. And remember, whenever we're dealing with the debt buyer, we want to start with that basic foundation of, can the debt buyer prove it owns the debt? Can it prove it really bought the debt? If it cannot prove that, then in my view, and the way I've argued these things since 2006 at least, is nothing else matters, because they're not the right person. Just like I don't owe my mortgage payment to you. You don't owe your car payment to me. Okay, I can't sue you for your missed car payment. Judge will say, so what, John? She doesn't owe you the money. He doesn't owe you the money. So that's the starting point. Can they prove they own it? And then you do look for these discrepancies where they might have different dates of last payment, different amounts. Check your credit report. What does your credit report show? It might have Synchrony Bank on there. Does it have one balance and then Portfolio's on there and it has a different balance? Now, Synchrony should not have a current balance. It should be zero. But you can look through the history and see, well, what was the last balance they show? Compare that to Portfolio Recovery. Are they the same or are they different? That can be very helpful. So definitely get with a lawyer in your state, help you go through this, because there might be violations of the Fair Debt Collection Practices Act, and might be some valid defenses here for you in this lawsuit. And wish you the best of luck, and thanks for the great comment. All right, guys, bye-bye.